Developing news in the sex crimes investigation into 4 former Vanderbilt football players. As we've reported, a grand jury indicted Corey Beatty, Brandon Vandenberg, Brandon Banks, and Jaborian McKenzie on rape and sexual battery charges. That indictment followed a 6-week sex crimes investigation by Metro Police. All 4 were dismissed from the team a few weeks ago. Well, now Joshua Brand, a criminal defense attorney here in Nashville, joins us. And Joshua, I'm sure folks at home are wondering, what does a defense attorney do first after a bombshell indictment like this?
Well, obviously, in order to be able to prepare any sort of defense, you have to know what evidence they have against you. That'll come in 2 forms. Once they're actually arraigned, they go into court and probably plead not guilty. They'll engage in a formal discovery process whereby the state shows them basically what evidence they have. They may show the state what evidence they have. At the same time, and probably even before that, they'll begin their own investigation, looking for their own witnesses, additional witnesses the state might not know about, checking into other kinds of evidence, text messages, cell phone records, other security surveillance, whatever they can really find.
Obviously, this is embarrassing for Vanderbilt, for the football program. Is it likely that this case or these 4 cases will actually go to trial, or do you think it's more likely that the players may reach some sort of plea bargain to avoid all of the publicity?
Well, I would say in a high media case, it's probably somewhat more likely they would go to trial, but a really high percentage of criminal cases, any cases really, settle ahead of time. And it'll really depend on how strong the evidence is against them, what kind of defenses they might have, and what kind of negotiations they're able to engage in with the state when there's so much media coverage and this is such a big deal for everybody involved.
All right, let's talk time served now. If they are convicted, what kind of punishment are we talking about?
Well, each of the aggravated rape charges is an A felony. It carries 15 to 25 years for an individual with no prior felonies, which I would probably presume these kids don't have. So with 5 charges, that could be up to 125 years for the rape charges alone. Each of the aggravated sexual battery charges carry 8 to 12 years. That's another 24 years. That could be stacked on top. So we're looking at possibly 149 years. Could be less than that, obviously, but anywhere from 15 to 150 years.
And for Mr. Vandenberg, he faces additional charges, allegedly taking pictures of the incident,
right,
and also of tampering with evidence, possibly trying to dispose of those pictures or any evidence of them. How does that play into his sentence if he were convicted?
Well, they could be factors that could give him a slightly higher sentence. I mean, with that many years, those are lesser charges. They carry a lesser sentence. They're of somewhat less concern. They're serious, they're still felonies, but not nearly as concerning for a defense attorney or a prosecutor as the rape and the aggravated sexual battery charges.
All right, some of the attorneys for some of the players, we've been in touch with them today, and they told Fox 17 that they felt like they were ambushed. They did not know the indictments were coming. Is this fairly common?
Well, yes and no. There's 2 ways that you can be formally charged with a crime. You could just be arrested, essentially, in which case you would go to General Sessions Court, have a preliminary hearing, they would put on some evidence, maybe even have the victim testify, and then it would go to the grand jury. The other way they can do it, and this happens in more serious cases, murders, rapes, really, really big drug investigations, is they'll go directly to the grand jury and say, this is the evidence we think we have or we do have, and we'd like you to just charge them right off the bat. I would say that this time frame is relatively short to go to the grand jury, but my suspicion is these individuals knew there was an investigation going on. They knew they might or probably would be charged at some point, whether they knew it was today, next week, 6 months from now, maybe not, but I'm not sure I would call it quite an ambush, as they didn't quite know the timing of it.
And how hard, honestly, is it to defend a case like this?
It can be very, very difficult, and again, it comes down to what kind of evidence do they have? Do they have DNA evidence? Do they have photographs of all these, or pictures, cell phone stuff of all these individuals in the room? Were there other people there that can say they saw this going on? It's hard to say. It's different if it's one person saying something happened versus 10 people saying something happened with DNA evidence.
All right, Joshua Brand, criminal defense attorney here in town. Thank you for being with us.
Thank you
I know
very
you'll
much.
be with us again in the next hour.
Absolutely.
Thank you for your insight tonight.